Think your on-demand guarantee is as good as cash? In China, $179 million was frozen in just 48 hours because of one document the owner signed. Welcome to This Explainer. Today, we're going to unpack an absolutely crucial, yet highly misunderstood legal reality in the world of cross-border EPC projects. That's engineering, procurement, and construction. We are looking at a fascinating breakdown of exactly how the Chinese legal system handles independent guarantee bonds. So if you operate internationally, you definitely need to understand this. Let's dive right in.
In the international commercial space, independent guarantees are essentially viewed as an automatic cash machine for the beneficiary. The standard expectation, which is based on international rules like URDG 758, is that the bank's obligation to pay is completely, 100% independent of the underlying contract disputes. You present the conforming documents, and boom, you get paid, right? It's the classic pay first, argue later rule. And the whole point of this is to give overseas project owners rapid financial compensation without having to jump through hoops to prove a contractor defaulted first. But, as we're about to see, under Chinese legal jurisdiction, this golden rule, well, it's not absolute.
$179 million. I mean, just let that number sink in for a second. That is the exact amount the Beijing Financial Court ordered to be frozen in a recent landmark stop payment case. And here is the kicker. This wasn't some drawn-out, multi-year legal freeze. This massive sum of cross-border funds was halted in just 48 hours. And it was all because the specialized Chinese courts found that the project owner had signed a single routine document that legally completely undermined their right to claim those funds. This case was so significant, it's actually been included in the Supreme People's Court Work Report as a standard-setting example.
Okay, let's shift gears and look at our first major section, the legal reality, the fraud exception.
To really grasp what happened with that $179 million, we have to transition away from that international expectation of pay first, argue later, and look at the strict legal reality under Chinese jurisdiction. The core legal mechanism that actually allows Chinese courts to step in and block these payments is known as the fraud exception. Under the Chinese Supreme People's Court's judicial interpretation on independent guarantees, there are 5 very specific scenarios where a claim is legally considered fraudulent. But for international owners, the absolute most dangerous one is Article 12, Item 5. It's called the Abuse of Rights Clause. Basically, this clause kicks in when a beneficiary maliciously claims payment while fully knowing they have no right to do so. So the court steps in to maintain substantive justice. They aren't looking at minor, everyday contract disputes. They are looking to see if your claim is morphed from a legitimate risk hedge into a deliberate, calculated abuse of the guarantee's independent nature.
Moving right along to our next critical area, the acceptance trap and the waiver evidence. Now, you might be wondering, how exactly does a court determine that you knew you had no right to the money? Well, it usually comes down to your own paperwork. Specifically, there are 2 fatal documents you absolutely must avoid mismanaging. First up is the Project Acceptance Certificate, or POAC. Think about it. If you, as the project owner, sign this document, you are legally confirming that the project facilities have passed inspection and are ready for operation. If you sign that and then later try to call the bond claiming the contractor failed to deliver or delayed the project, well, the court views your own signature as a complete negation of your claim. Second is the force majeure waiver. Let's say there were massive delays because of a pandemic, and you wrote a letter acknowledging the force majeure and promising not to hold the contractor liable. If you later turn around and try to pull the bond for those exact same delays, that letter acts as ironclad evidence of fraud. Signing either of these documents without heavy, explicit reservations legally destroys your right to call the bond. So the ultimate judicial test for an abuse of right really comes down to this standard. Is the beneficiary maliciously claiming payment while knowing they have no right? To figure this out, Chinese courts use what they call a limited necessary review. Essentially, they pierce through the independence of the bond just enough to look at the underlying basic facts. If they peek behind the curtain and see you signed a waiver or an acceptance certificate, they figure any reasonable person would conclude you have no factual basis for a claim. And at that point, you aren't just arguing over a breach of contract anymore. You have crossed the red line straight into fraud.
All right, let's look at how fast this all happens in our next section, the 48-hour freeze.
If you trigger this fraud exception, the consequences are immediate. And I mean immediate. We're talking about an incredibly fast, highly specialized legal procedure. Step 1. The contractor applies to the court, providing preliminary evidence, like that specific certificate you signed, along with a security deposit. Step 2. The court conducts an entity review within just 48 hours to see if the situation matches those Article 12 fraud conditions we talked about. Step 3. If they see a high probability of fraud, boom, they issue a stop payment order that is executed immediately.
The banks are notified instantly to halt the cross-border transfer. And finally, step 4, even though you technically have 10 days to apply for reconsideration, the execution of the freeze does not stop during that time. So from the very moment the application is filed, your cross-border funds can be completely frozen in under 2 days. Your expected cash flow is instantly severed.
Navigating the fine line between a legitimate commercial dispute and a legally defined abuse of right requires extreme precision, especially when you're dealing with the specialized and highly efficient courts overseeing these massive infrastructure projects. And keep in mind, what we cover today, this is just the first layer. I haven't even covered the specific double abuse of rights test that's actually required to stop a counter guarantee between international banks. There is a whole lot more to this, so if you want to protect your overseas interests from these kinds of traps and learn more about navigating China-related legal risks, I've shared more practical insights on my LinkedIn. You can find me here, www.linkedin.com/in/rongqingjang-824282169. Definitely connect with me over there.
Which leaves us with this final thought. When just one routine signature on a project acceptance document can freeze $179 million in 48 hours, the stakes literally could not be higher. So, how will you balance your aggressive commercial claims with the strict, incredibly fast-acting reality of legal compliance in China? It's a critical question every single international contractor and project owner must answer before they ever attempt to pull that bond. Thanks for joining me for this explainer, and I'll see you next time.